Okay, so you're very welcome to the second session of the day. I'm Coleman Dennehy. I'll be sharing this session. We have four speakers today on the general topic of punishment, war, and politics, which I'm fascinated by, and I'm very much looking forward to hearing these papers. We're going to follow the order as it's laid out in the program. So every speaker will have approximately 15 minutes. So I'll give a little heads up when you look like you're about to transgress our normative forms of presenting papers. So we will start first with Jakub Novák from Masaryk University Faculty of Law, who will be speaking on the topic of dishonourable discharge from the army in the military criminal law of Czechoslovakia, Ilić, and Russia.
Thank you.
Over to you, Jakub.
So I'll just start sharing the presentation. Thank you for the introduction. I'm a PhD student at Masaryk University in Brno at the Department of History of Law and State. And generally my dissertation is, the topic of my dissertation is the law and legal system of Czechoslovak region in Russia. So I'm now going to talk about a small part of it. But we need to start with the general things. So very shortly, what were the Czechoslovak legions in Russia? Or Czechoslovak legions at all. At the beginning of the 20th century, at the beginning of the World War I, the later Czechoslovakia was part of Austro-Hungarian Empire. So when the war broke out, the Czechoslovak resistance abroad was formed. This resistance had two branches, the political one and the military one, which was called the Czechoslovak legions. These legions were volunteer military units of Czechs and Slovaks mostly, which formed on the Entente side in most of the Entente armies. They were comprised of emigres and later of prisoners of war, generally mostly in Russia, because in Russia there were most Austro-Hungarian prisoners of war, of whom the Czechs and Slovaks volunteered to the legion later. As I said, these units formed in most of the Entente armies. On the right side, you can see the post-war poster, which showed the numbers of soldiers who fought in each of the Entente armies. As you can see, the legion in Russia was by far the largest one, with more than 70,000 members. But when Russia left the World War I, after the Peace of Brest-Litovsk, the legion in Russia was declared a part of the French army, and it was supposed to move through Vladivostok to France and continue the fight on the Western Front. But in May of 1918, after the so-called Chelyabinsk incident, animosity between the Legion and the Red Army broke out, and the legions got involved in the Russian Civil War, in which it ended up fighting for 2 years. So this is a propaganda poster from the time of the legion's fight at Siberia. It's called "We Are Whitening," like whitening the Siberia, fighting for the white forces. But I'm not showing just for illustration purposes, but you can see the whole area the legion with only 70,000 members had to control from Penza to Vladivostok, while at this time being cut off from the Czechoslovak National Council and the Entente Command. And thus, in this time, the legion had to create its own system to work with. They had their own economy, they had their own medical system, their own hospitals, and also what is the most interesting thing for us lawyers, they had their own legal system. So this legal system had its own system of courts. We can divide it into the early system and the late system. The early system was established in March of 1918, and it had 2 levels, but no appellation. There were 2 levels of courts, but only 1 instance. The first level were regimental or trained courts. That's mostly the same type of court. There was only difference on how they were established. And on the second level, there were so-called field courts. The regimental ones had to deal with the lower level crimes, while the field courts dealt with the higher level crimes. But there was no other connection between them. There was only minimal legal regulation, since the legion had no legislature and they had no laws with them. They had only about 30 lawyers within the legion, so they had to either make up their own regulation or work with what they remembered from Russian and Austro-Hungarian law. And dishonorable discharge was punishment at the work as punishment at this time, but it could be used by both level of courts, which brought problems with too many people being discharged. I will talk about this a bit later. In February 1919, there was a necessity to make the system in Russia, of the Legion in Russia, closer to the system of military courts in newly established Czechoslovakia. So it was reworked. It was now 3-level. The appellation was finally introduced, so you had 3 levels of courts and 2 instances. You can always appeal once. There were still regimental courts. The field courts were replaced with 4 division courts. And then there was a corps court, which served as the supreme court body in Siberia. There was better legal regulation. In theory, they were supposed to use the Czechoslovak legislation, but in fact, this legislation never got to Siberia. They had one book of laws for all the courts. There were around 50 courts at the time. So in reality, they still had to work with what they could remember, or now that they had the corps court, this one supreme body was able to somehow make the decisions of the courts somehow unified. Now the dishonorable discharge was limited only for division courts and corps court, as there was an intention to limit the number of people being discharged, as the army wasn't that big and there was it wasn't possible to keep fighting the more than 10 times larger enemy with parts of your army being discharged. So, just for illustration, these are members of regimental court in Yekaterinburg. And now, introduction of dishonorable discharge. What is dishonorable discharge? In general, this is a military punishment which leads to the fact that the soldier is discharged from the army. He leaves the army without the ability to use any benefits of his veteran status. Also, he is usually stripped of rank and these things. Within the Legion, this had some other specifics. It was introduced in the January of 1918, even before the court system was established. So at this time, there were 2 ways. If you were an enlisted soldier or non-commissioned officer, you would be discharged by the commander, by your commander, on the proposal of company committee. Company committees were elected bodies of companies. Legionnaires were fanatically democratic. They had elected bodies for everything, and this was one of them. If you were an officer, this was a bit more difficult. You had to be voted out of the officer corps by all other officers in your unit, and then you would be discharged by the branch of Czechoslovak National Council in Russia. But this system worked only up to the March when the courts were introduced. The result at this time would be that you would either return to your civilian life if you were just a Czech expat living in Russia, or either if you were a volunteer from the prison camp, you would return to the prison camp, which might have been dangerous because at this point you were considered a traitor by other Austro-Hungarian prisoners of war. Here you can see the order on which the dishonorable discharge was introduced into the army. It's in Czech, so I'm afraid most of you won't understand it. But when the courts were introduced, at this moment, punishment of dishonorable discharge, as I said before, was possible for both levels of courts. Usually it was not a sole punishment, but it was followed either by capital punishment, which was not used so often at the time, but mostly it was together with punishment of prison. The legionnaires even built several of their own prisons in Siberia, which they used for the soldiers who misbehaved. It was used extremely often. On that level that they had to introduce possibility of rejoining the army if the person redeemed himself, because the Legion had around 70,000 men and hundreds of discharged soldiers were missing on the front at the time. So from the autumn of 1918, there was a possibility to rejoin the army, and actually it was used very often. Most of the soldiers who were discharged actually applied to rejoin the army. not all of them actually rejoined, because usually this was rejected on the basis they did not really make their behavior better, and they would make stain on the honor of the Czechoslovak army. The result was, however, still the same as before. Still, the soldiers returned to the civilian life or to prison camp, because at this time the Czechoslovakia did not exist yet, and the soldiers still were not technically citizens of Czechoslovakia, so they had nothing else to do with them. But this all changes in the late system. From the beginning of 1919, there were attempts to limit the number of dishonorable discharges. One of the main results of this, as I said before, was the fact that regimental courts no longer could use dishonorable discharge as a punishment. This worked very well, as between February and October, the number significantly decreased from 44 dishonorable discharges in February to only 10 in October. And all of these were made by the divisional court in Vladivostok, which generally just did not follow any orders he was given about the punishments it should use. As I said, the regimental courts no longer had this right, but the result was much different at this moment, because the news about establishment of an independent Czechoslovakia got to Siberia at this time. So all the soldiers were citizens of new Czechoslovakia. They couldn't just leave them in Siberia. And also, most of the soldiers wanted to return home, so they couldn't just kick them out of the army and send them to Czechoslovakia, because there was the chance that the soldiers would commit crimes just to get kicked out of the army and get to Czechoslovakia sooner. So the idea they used was that they created labor units which worked next to the army but weren't considered part of the army, and soldiers who were discharged were forcibly transferred to these units and worked there until the time they would normally be sent back to Czechoslovakia came. We've talked about the consequences during the war, but there were also important post-war consequences for the legionnaires who were discharged. First of all, most other sentences, all the prison sentences, capital punishments and these things, were subjected to presidential amnesty after the war, with the exception of the most severe crimes, usually murders and rapes. For example, deserters and those who deserted and joined the Red Army were pardoned after the war. But discharges were generally left out from this amnesty, so discharges still apply. The most important consequence of being discharged was the loss of entitlement to Legion veteran status, or status of the legionnaire, if I use the terminology of the law. This was a very important consequence, because legionnaires after the war were considered national heroes. They had preferential rights to be employed in civil service. They had preferential rights to become officers in the army, to join gendarmerie, police, postal offices, and these things. And they had much higher veteran pensions. Also, if they stayed in the military, they had higher pay. So all of these things were lost to those who were discharged during the war. However, if the soldier joined the Czechoslovak legions as a veteran of Austro-Hungarian army, as a prisoner of war, he still had the status of Austro-Hungarian war veteran. So they had kept their pensions and rights coming from the veterancy in the Austro-Hungarian army. Now, as a conclusion, generally, the legal system of Czechoslovak Legion in Russia is a very interesting thing, because we can study ad hoc made legal system without any laws possible to use for the army. So it's a legal system which was created out of nowhere, which worked for 2 years and actually was functional. With having some of the specifics of the army fighting in war with smaller numbers, and having specifics of using specific punishments which were known to other armies at the time, but had specific consequences for the soldiers who were fighting for, at the time, non-existent state. So generally, this could be taken as something interesting to study for the evolution of newly established legal systems. I thank you for your attention, and I'll be looking forward for any questions.
Thank you very much, Jakub. I think similar to all the previous sessions, we'll keep our questions towards the end, if that's okay. I'm sure there'll be plenty of them. So next up, are we doing musical chairs then? We're going to move about, yeah?
Yeah,
Yep,
because I
excellent.
need a presentation.
Yeah, no problems. So next up is Andreyevich Kiosov from St. Petersburg State University. He will be speaking on coercion, punishment, violence in the Russian history of legal and political doctrines of the 20th century, general trends and cross-cutting themes. Okay, it's over to you, Andrey.
Good morning, dear colleagues. It's a great honor for me to present my work at the Faculty of Law of the University of Belgrade. In advance, I want to apologize for my level of English, but still I think that we will understand each other. In my work, I present an overview of Russian political and legal thought in the 20th century, analyze the attitude of representatives of philosophy and theory of law on the topics of coercion in law, punishment and offenses and violence. The first cross-cutting theme is countering the use of death penalty. Some representatives of Russian philosophy and theory of law were characterized by a position to countering the use of death penalty. One of the representatives of this trend at the beginning of the 20th century was a professor of the Faculty of Law of St. Petersburg University, Nikolai Tagansev. According to Tagansev, Russian criminal law has been developing since the 18th century in the direction of limiting the death penalty. Tagansev has argued for many decades that the death penalty is not only impractical, but also harmful, because in public life, everything that's impractical is harmful and under certain conditions unfair. Tagansev in his scientific work not only gives doctrinal theoretical arguments in favor of abolition of the death penalty, but also refers to the practical foreign experience of Italy, Holland, Belgium, and other European countries, where after the abolition of the death penalty, the number of murders continued to decrease. The first 2 decades of 20th century became a time of revolutions for the Russian state, the revolution of 1905-1907, the Revolution of February 1917, the Revolution of October 1917. Tagansev keenly felt how high the problem of political fanaticism was at such a time. According to Tagansev, the threat of execution will not deter a political fanatic going to a crime. Tagansev is convinced that the state should faster stop committing violence than offenders. The state should start because the functions of the state are such it should educate nation to respect the individual freedom, and this is not presented the execution of the penalty. Throughout the 20th century, tendency to turn to religion was manifested in the works of some philosophers in Russia. According to the philosopher Nikolai Berdyaev, the kingdom of Caesar is opposed by the God's kingdom of spirit and human freedom. Berdyaev condemns the death penalty by appealing to morality. The state was born in bloody murders, but it also made murder a law and recognized death as one of the laws of life. Berdyaev, being a religious philosopher, recalls the events from Bible. If Christ's death on the cross was a victory of death, when at the same time it was also the most powerful religious condemnation of murder, the one who executes with death, true Christians claimed, joins the cause of the tormentors of Christ, kills not only man, but kills also God. One of the authors of the text of Constitution of the Russian Federation of 1993, lawyer Sergei Alexeyev, also addressed the arguments about the institution of death penalty at the end of 20th century. According to Alexeyev, in a society built on the foundations of an authoritarian regime and located at a low stage of civilizational development, murders by the state are an ordinary, natural, justified matter, no matter how it's called. Death penalty, liquidation, capital punishment, deprivation of the right of correspondence. According to Alexeyev, human civilization at the present level of its development is designed to affirm the absolute sanctity of human life. And the death penalty as an act of killing one of the members of society is a recognition by society of its unwillingness to waste time on the re-education of the offender. The largest Russian philosopher of law in the second half of the 20th, beginning of the 21st century was academician of Russian Academy of Science, lawyer Vladimir Nersisyans. In my opinion, Nersisyans expressed the most consistent and academically reasoned opinion about the place of the death penalty in the modern system of punishment by referring to the political and legal teachings of Immanuel Kant and his concept of equivalence. However, death penalty is legally equivalent to only one offense, premeditated murder, which destroys the absolute and highest value in the form of human life. The provision of death penalty for any other offenses is not equivalent and means the establishment of anti-law punishment. Such a free establishment contradicts the principle of justice. The absence of a death penalty for premeditated murder in the system of punishment is a refusal to comply with the principle of equal legal responsibility. The refusal to commit the death penalty is a consciousness of firm and self-confident law and order in favor of milder social mores without any serious danger of questioning the principle of requirements of law. So in other words, it's transferred from the actual state to the potential state, but it always remains the reserve of the law. There is a mistake on the slide because in Russian language, two words, law and right, has the same meaning, право. As long as there are murders and as long as there is a state and a law. As an addition to the words of Nersisyans, I would like to recall that in the Criminal Code of 1926, the death penalty was formally absent from the list of types of punishments, but at the same time, it was actively used as an extraordinary type of punishment. It was on the basis of the articles of the Criminal Code of 1926 that a huge number of death sentences were imposed in the 1930s in Russian history. The humanist Nobel Peace Prize laureate Andrey Sakharov also condemned the death penalty. Sakharov's activity had a significant impact on the reform of the socialist state at the end of its existence. Having no special legal education, Sakharov allows lawyers to look from the outside at the unprofessional legal society and the public opinion, which very often differs strikingly from the opinion of legal scholars and scientists. So Sakharov writes, at the same time, I know that public opinion, people who are not legally savvy and are not familiar with statistics, with the state of affair in the field of crime, who don't have relevant social experience, they often speak out for the use of the death penalty. And Sakharov offers his way out of this situation. It's necessary to conduct explanatory work among the population. It's important that lawyers, psychologists, psychiatrists, doctors, and journalists conduct appropriate work. And I would like to recall the thought of Lev Leon Petrozhitsky at the beginning of the 20th century in the works of Dean of the Faculty of Law of St. Petersburg University, Polish and Russian author Leo Leon Petrozhitsky. Psychological theory of law was created. Law, according to Lev Petrozhitsky, is a fact of mental life. He proposed to supplement the existing system of legal discipline with one new legal discipline, legal policy, which would fulfill the tasks of rational direction of public consortions and behavior, cleansing the psyche of antisocial tendencies in the non-legal society, and the development of social legal education. So the second theme is attitude towards the executors of punishment. Some representatives of the Russian philosophy of law of the 20th century described the negative attitude towards persons executing punishment. The writer and the philosopher Leo Tolstoy was the creator of his own religious teaching, which reflected to the themes of law, the state, and the punishment. Leo Tolstoy's specific views combine the ideas of several concepts: positivism, class theory, and anarchism. Leo Tolstoy was an ardent critic of the very fact of the existence of law and all legal instruments, including punishment. He warns, after all, death, even you are not killed, it's always behind all of us. Can't you see in your bright moments what your vocation in life cannot be to torch, kill people, tremble with fear of being killed yourself? Nikolai Tagansev calls the executioners masters of their craft, the craft of depriving people of life. Tagansev states the negative public opinion about the executioners. It's well known with what disgust the people look at the executioner. Only in our time can one imagine that there are people who voluntarily take on this responsibility. Andrey Sakharov writes, I have spoken out and I'm speaking out against the death penalty also because this measure of punishment provides for the existence of permanent terrible apparatus of perpetrators, the whole institution of death penalty. Let's go to the third theme, the theme of new interpretations of political and legal doctrines in the past. The Russian philosophy of law is characterized by frequent intentional revisions and distortion of thoughts written by philosophers and legal theorists in the past. Especially such actions were characteristic of the socialist stage of the development of law and the state. Vladimir Lenin was a graduate of the law faculty of St. Petersburg State University. He wrote that law is nothing without apparatus capable of enforcing compliance with norms of law. According to Lenin, every state is organized coercion and systematic use of violence by one class to another class. The dictatorship of a class is a domination of this class over all other social groups. Lenin writes, a dictatorship is a power based directly on violence, not bound by any laws. The new proletarian state, therefore, is being created with the same purpose of violence, which, according to Lenin, was characteristic of all states in history. The representative of legal positivism of initial stage of development, socialist law and the state, is the University of Faculty of Law, St. Petersburg University, Evgeny Pashukanis. In my opinion, he most fully revealed Lenin's philosophical statements about place of violence and coercion in law, and about the place of new Soviet law in general historical context. Pashukanis defined socialist law as a law with proletarian class essence, content, with the bourgeois form. Pashukanis was skeptical about the formal fake change of the theorists of socialist law. For example, Pashukanis perceived the replacement of the term punishment with social protection measures in the criminal code of 1926. For the purely terminological refusal and not affecting the content of the institution of punishment at all. After Stalin came to power in Soviet law, the process of composing such a definition of law that would contribute the goals of strengthening began. Stalin had no higher university education at all, so he entrusted the conduct of legal affairs to the prosecutor of the USSR, Andrey Vyshinsky. In 1938, the general line in Soviet law was officially proclaimed, which did not imply any other ideas of Soviet law and the state, except for the one that was officially established. For example, Evgeny Pashukanis, had already been executed as a follower of Trotskyism and as an enemy of the nation. So I'd like to say that Pashukanis was rehabilitated in 1956 after the death of Stalin. In Stalin's year, punishment was considered as a system of political measures, as one of the political instruments of power in the class struggle. Law in any state, according to Lenin, simply boils down the violence, and violence in any historical periods, and not only at the stage of new proletarian law. The special feature of proletarian law was only that violence in it was carried out by the proletarian, other non-proletarian classes, and not other species at all. The philosophical concept of law and state in Lenin's dialectic were only technical concepts and were not filled with internal value content. In my opinion, Soviet lawyers of the post-Leninist period used traditional legal terms, including coercion, punishment, violence, etc., and constructions in condition of abuse of the legal dictionary. This was done to intentionally create terminological confusion in order to justify, with the help of legal categories, of non-legal phenomena. Professor of the Faculty of Law of St. Petersburg University, Ginevra Lukovskaya, argued about the infinity of possible interpretations. In her opinion, no interpretation is complete. I fully agree with the opinion of Ginevra Igorevna. Each process of interpretation, and especially interpretation of the political and legal doctrine, with the development of an origin interpretative concept of the doctrine. In addition to the fact that in the real world, any legal scientist simply does not have enough words to describe all the complex phenomena of law. So also the consciousness of each scientist is individual. The ideas of Ginevra Lukovskaya about the multiplicity of interpretations are based directly on the internal cognitive processes of the individual consciousness of a particular interpreter. However, the power-oriented interpretations of Lenin's words appear as an example of what a powerful, like state ideological or communist party, etc., attitude to the revision of the past and the search for justification, legitimization of political actions can do with the science. Most interpretation of Lenin's provisions are not reasoned, scientific, and academic in nature at all. That's why, in my opinion, such substitutions cannot be called scientific interpretations. So the next theme is violence breeds violence. Nikolai Tagansev divided all the variety of theories and concepts of punishment into two main groups. The first is called theories of retribution, or in other words, theories that address the past and see in the punishment only the retribution for the committed aggression. And the second group is utility theories, or in other words, theories that address the future and see in the punishment the rational activity of offender for the state. The theories of retribution are characterized by the commission of the violence by the state for violence committed by an offender, by a person. University of State, St. Petersburg University, anarchist philosopher Peter Kropotkin claims that brutal murders came out of the crowd that accumulates around the prison on the night before execution and waits for the morning killing. At the same time, he has no doubt that the fact of the existence of the death penalty supports the idea in society that murder is a good means of retribution for all people. I note that Peter Kropotkin applies the statement violence breeds violence only in relation to the death penalty and murder, although in my opinion there are no obstacles to extending this thesis to other offenses and punishment. Nikolai Berdyaev very accurately described the circle of violence characteristic of human geometry. Having entered in once by committing a little crime, we will receive the answer in the form of even more violence. In this circle, both the state, by imposing sanctions, and the offender, by violating the crime, commit violence. And it's extremely difficult to get out of this circle. The last theme is conditions of Soviet sentences. The culture of the beginning of the 20th century had a bright literature-centric character, in connection with which the activity of writers was given great importance both in public thought and in philosophical thought. The famous Russian writer Anton Chekhov wrote a book of the same name after his trip to Sakhalin Island. This book is called Sakhalin Island. In this book, Chekhov described the depressing situation of Russian offenders served in sentences on Sakhalin. Chekhov wrote, "The exiles have vices and perversions, which are mainly characteristic of people who are forced, enslaved, hungry, and in constant fear. Deceit, cowardice, fraud, theft, and all other kinds of vices. This is the arsenal that the exiles have." After the publication of the book, a delegation of lawyers was sent to Sakhalin Island, and in fact, they verified conclusions about the terrible situation of offenders which were at the island, and were truthfully described by Chekhov. And the lawyers who returned from Sakhalin Island submitted a detailed report to Minister of Justice, and this report seriously influenced their preparation of the reform of the Siberian exile in the beginning of 20th century. So unfortunately, due to lack of time, I cannot tell you more information about the topics of the speech and other cross-cutting themes in Russian history of political and legal doctrines. So I'd like to stop now and thank you for your attention.
Splendid, Andrey. Thank you very much. I'm very well understood as well, I might add. No need for always heightens my awareness of my own language privilege that I'm one of the few native English speakers in the room, and other people are apologizing for the lack of English ability, but not in this case because there's no need. So we now move on to Jan Tranžík, also from the Masaryk University, who will be speaking on the trial of Jozef Tiso. Tiso. Okay, all yours.
So, wait, I will just launch the presentation. Probably share it to the. Yeah, it should work. So, ladies and gentlemen, thank you for the introduction. In my presentation, I would like to tell you a story and to introduce you into a trial and punishment of Jozef Tiso. I have chosen the topic as a logical continuation of my last topic on Iustoria, which was a few years ago, and which was about the fates of Jewish community in Nitra, in Slovakia. Well, this year I'm going to research the fate of the man who was arguably somehow responsible for that. The man is Jozef Gaspar Tiso. He was born on the 13th of October 1887 to a religious Slovak family in Bytča. Then it was part of Kingdom of Hungary inside Austro-Hungarian Empire. The people in Bytča spoke Slovak, but the elites were mostly Hungarian or German-speaking. It's probable that in this environment, Jozef started to think something like that. maybe Slovaks should not live as a minority in someone else's empire, but rather to have a state on their own. So here is where his Slovak nationalism begins. He studied theology, and in 1910 he became a Catholic priest. A few years later, he was appointed to the parish of Bánovce nad Bebravou as a vicar, and he retained this function all the time. Even as the president he later became, he celebrated a mass in the small town Bánovce every Sunday. After 1918, now in Czechoslovakia, so not anymore Hungary, Tiso became a member of HSLS. That means Hlinka's Slovak People's Party, led by Andrey Hlinka, which was at this moment not a fascist party, but rather a Slovak nationalist party seeking some autonomy for Slovakia, but within the Czechoslovak state. It was not an anti-establishment party. Indeed, it was sometimes part of coalition government of Czechoslovakia in Prague. And for a while, in years 1927 to 1929, Tiso was a minister of public health and physical education in Czechoslovak government. Well, in the 1930s, the atmosphere in Central Europe and in Czechoslovakia in particular was getting worse as the Nazi Germany was becoming more aggressive. Adolf Hitler was, besides other things, aiming to destroy Czechoslovakia at all. In 1938, two things happened. Andrey Hlinka died, and Jozef Tiso became the leader of Hlinka's party after him, becoming one of the most important figures in Slovakia. And Munich Agreement was signed, which weakened Czechoslovakia severely. Only a few months later, in the spring of 1939, Nazi Germany occupied Czech lands, creating the so-called Protectorate Bohemia and Moravia. To avoid a similar fate, Slovakia declared its independence, of course with Hitler's agreement. And later in that year, Jozef Tiso was elected the first president of the so-called Slovak state. On the photograph, we can see Tiso shaking hands with Hitler, who was all the time more or less his protector, and the Slovak state is often considered to be, indeed, a puppet state of Nazi Germany. It also had authoritarian and fascist characteristics. It did not respect its own constitution and laws, as I showed 2 years ago. And a paramilitary organization named Hlinka's Guards had much more power than it probably should. Jozef Tiso, as the president of the Slovak state, was at least politically responsible for the actions of the state, although he was not the most radical person in the Slovak leadership. It is fair to say there were people like Wojciech Tuka, who were even more radical fascists and Hitler's admirers. It should be also mentioned that as a president and a priest, Tiso was genuinely respected by many Slovaks. As far as I know, for example, here in Serbia, the regime of General Milan Nedic has almost no authority, and most people were living under the occupational regime only out of fear. Well, in Slovakia, it was not like that. Arguably, the living standards in the country were better than in most parts of Nazi Europe, which is what Tiso's admirers like to accent. But it was definitely still not an ideal place to live. In 1944, when it was clear that the Nazi Germany was losing the war already, a Slovak national uprising began. Tiso could not manage it himself, so he basically allowed the German army to suppress the rebellion with brutal force. Whole Slovak villages were destroyed at the time. Tiso was still a president, but his authority was already weak. Let's say, when people who lost their relatives in the uprising saw photos like this, where Tiso decorates the German soldiers who were responsible for the war crimes, they could not respect him anymore. In the spring of 1945, Jozef Tiso, the president of Slovak state, had to run as the Soviet army was coming for him. First, he sought asylum in a monastery in Kremsmünster in Austria. Then he moved to Germany, and there he was captured by the US Army. Eventually, he was extradited to Czechoslovakia. He was transferred by air first to Prague, then to Slovakia. He was kept in detention to be judged by the National Court in Bratislava, which is the capital of Slovakia. On the picture, we can see Tiso coming out of the airplane in Triduby in central Slovakia. The National Court was not a normal court, but rather a special institution created only after the war with a single aim: to judge and punish the fascist criminals, occupants, traitors, and collaborators. The judicial chamber of the court consisted of 7 judges. Most of them did not need to be professionals. Only the president of the court and his deputy had to be. The judges were appointed by the Slovak National Council, which was a political body, and they were appointed basically by the political criteria. They represented the political parties who were in the council. The president of the chamber, who was therefore Tiso's main judge, was Doctor of Laws Igor Daxner. He was a member of Communist Party of Slovakia. The defense later tried to claim that Igor Daxner is not an independent judge, but this claim was not upheld. Here we can see a photograph from the trial where Jozef Tiso, in the right side of the photograph, is giving speech. The trial itself started almost 1 year after Tiso's arrival to Slovakia, because it had to be carefully prepared. It was a great trial, and it was really popular. The benches for the public in the courtroom were always full. As much as 3,750 attendants came to take a look at the trial. And due to presence of the international press, the speeches were even interpreted into foreign languages, such as English, French, and Russian. As I said, the main judge was Dr. Daxner. Then there were 6 other judges, 3 prosecutors, each for a part of the indictment, then 2 defense attorneys, Ernest Žabkaj and Martin Grecho, and Jozef Tiso. But he was to be judged together with 2 other Slovak politicians. Ferdinand Jurčanský, however, was at the time somewhere in America. He managed it to escape. And Alexander Mach, the former Minister of Interior, was present, but his case was excluded into a separate trial. And so on. Tiso was the only one actually sentenced in this trial. The main points of the indictment were breaking up the First Czechoslovak Republic, collaborating with the Nazi Germany, conducting the war against the Soviet Union and the Western Allies, fighting against the Slovak national uprising. It should be said the fighting national uprising was a crime, but only in Slovakia. And finally deporting the Slovak Jews into the German concentration camps. But this is just a short summary. In reality, the indictment had as much as 73 points. It should be said that unlike in the later political trials in 1950s, the defense attorneys were actually defending their client. Not like in the trial with Milada Horáková and so on, where your own attorney would demand the strict punishment for you. The defense and Tiso himself were generally trying to claim that Tiso did not know what was happening, or he knew it but he was not responsible, or finally that he knew about it, he was somehow responsible, but he was acting under duress. Unsurprisingly, Tiso has been convicted. He was found innocent of some parts of the indictment, like 17 of them, but he was found guilty in the most parts. The punishment was death by hanging. The judgment was in the name of Republic and Slovak nation, and the full judgment has 233 pages, and it's actually one of the longest judgments which were set in the trials after war. As it was a trial in national court, appellation was not possible. Tiso's attorney, Ernest Žabkaj, expected this verdict. However, he also expected that the president of Czechoslovakia, Edvard Beneš, was going to give Tiso a pardon, changing the verdict into life imprisonment. While Žabkaj sent the application for pardon to the presidential office immediately, Tiso himself did not really beg for mercy. Asked directly by the judge, he finally said, according to a moral obligation, yes. He meant that refusing the pardon would mean suicide, which was a sin for a Catholic priest. Although it was the president's personal decision to give pardon to Tiso, the other politicians had their opinions about it. And the communists absolutely did not want Beneš to give a pardon to Tiso. Then there was the Democratic Party. It was a main non-communist party in Slovakia, but they did not have clear opinion. Some Democrats wanted to execute Tiso, some did not. In the end, Beneš did not pardon Jozef Tiso. Finally, Jozef Tiso was executed in Bratislava on the 18th of April 1945 in the early morning hours. He probably believed he was innocent until his last moment, believing that he is dying as martyr of Slovak nation. So the story ends, but not quite. Less than 1 year after Tiso's death, the Communist Party of Czechoslovakia initiated a coup d'etat, so-called Victorious February 1948, getting all the power in the country for the next 41 years. The communist historians had clear opinion. They condemned the Slovak state and Jozef Tiso strongly. They described him as a Slovak ultranationalist, collaborator, and as a clero-fascist. Indeed, they used the fact that he was a Catholic priest in the propaganda against the Catholic Church extensively. In the 1990s, after the Velvet Revolution, in which the communist regime has fallen, the atmosphere has changed. Probably to the other extreme side, there were waves of Slovak nationalism, attempts to rehabilitate Tiso, even claims that he was a Catholic saint. Even today, Tiso's legacy divides Slovak society in a way. 4 years ago, a public survey called Největší Slovák, or the Greatest Slovak, took place. Tiso was included as one of the options people could vote for. However, this triggered a public outcry, after which Tiso was disqualified. It is improbable that he would actually win the contest. But it illustrates that people in Slovakia still have somehow strong emotions about him. The majority of Slovaks does not approve Tiso. A survey by a Slovak newspaper, SME, in 2007 showed that slightly less than half of respondents does not honor Tiso. 16.4% do honor him. That's not a majority, but it's still a big minority, let's say. And the rest does not have a strong opinion or do not know who Tiso was, especially the youngest people. Okay. Was trial with Jozef Tiso a political trial? We could argue that it absolutely was. It was a trial where the winners of a war were judging a loser of the war. Well, is every trial which is like this a political trial? I don't know. And I would like to know your opinions in the discussion. Well, one of the criteria for a political trial I have found is that the result is decided by the politicians rather by the judges. And also it is usually known from the beginning, even before the trial starts. Was the judgment known from the beginning in Tiso's case? Again, I do not know, but maybe not. While it would sound improbable that the court will declare Jozef Tiso innocent, at least the judgment was not clear. Some people did really expect that Tiso will be imprisoned, but not sentenced to death. I have found an interesting opinion on Tiso's trial said by Bishop Vladimir Chobrda. It should be noted that he was bishop of Evangelical Church, which was not at best terms with Tiso's Catholic regime, because Tiso strongly preferred Catholicism before evangelical churches. But Vladimir Chobrda said, if they repatriate him to Slovakia, they must judge him. If they judge him, they must convict him. And if they convict him, it means bad blood for Slovakia. So Chobrda implied the real decision was already made in 1945, when Czechoslovakia insisted that Tiso will be extradited by the US Army. And it should be noted that some other Slovak state politicians were somehow able to run into exile and therefore to save their lives. It should be noted that the trial was watched by the world press. And unlike in the later political trials, nobody from the abroad seemed concerned about Tiso's trial, and it was similar to the retributive justice trials after the Second World War all over the Europe. I'm looking forward for some questions and comments from you, and thank you for your attention.
Okay, thank you very much, Jan. Splendid paper, as I expected. So for the last but certainly not the least paper of the session, we move back to Belgrade, to Simo Ilić, who will be speaking on punishment as a means of oppression against free media. Well, here's Simo.
Okay.
First, I want to make some observation. The main objective here is to analyze use of punishment in suppression of media, but the most important aspect of this analysis is to compare it with other means of suppressing media, so we can find how effective it is and how dangerous it is. Now we will have press in the focus, but in some parts of Yugoslav history, there were no free press, so there were nothing to be oppressed, and in that part we are going to analyze suppression of art and other intellectual forms that aren't pressed. I want just to give a brief review of Yugoslav period. In the 19th century, you had a lot of censorship in Serbia and in non-Serbia Yugoslav parts too. And that was, you know, the trials for political opponents, usually with intention to cool their head, to give them, you know, about 1 or 2 years imprisonment, so they stop attacking the regime and things like that. The twist came in 1903 when the dynasty changed in Serbia, and we had the stop of this court oppression of political opponents, but the press was oppressed again, but now via extra institutional means. Usually the demolition team comes in the printing house, destroy machines once, second time, and few times, and then no one wants to publish it and no one wants to print it, and that was how the press was suppressed. But even that wasn't completely effective, because you could always print in the you could always print abroad and import printed media, so that wasn't completely devastating. After 1928, some restrictions were again the court was again used for this restriction, but not some severe as it was before. The conditions in the jails for political prisoners were better. They were separated from criminals. They had beds. They had large rooms. You know, 20 prisoners in a large room, and they could work. So you have the Das Kapital translated in our prison. You could see here, this is George Andreyevich Kun painting the Marx and the Engels in the prison. You have a lot of paintings by Moshe Piade also done in the prison. So they have fair treatment in the prisons. That wasn't, you know, we will destroy you. It was, be here, don't do bad things out in the free world. And we have then communist revolutions. It was a serious change. You know, we had purges after that, you know, with the estimation around, you know, 200,000 people were killed. Some of them deserve it, majority haven't, but the things are going to change. We have new government, we have Communist Party who don't want democracy, who don't want to share power or to allow other political party or other press than itself. So in that situation, we had a Democratic Party starting its newspapers, Democracy, and it was only oppositional magazine versus 130 communists. You had 2 more non-communist magazines, but they were not truly oppositional. You have the Republic, but they were communist, but not completely communist. at the beginning there were problems. There's no paper. The people who were selling them were beaten. One was killed, and it was taken away and burned publicly. So they would dance around, burn newspapers and things like that. And it lasted only for 42 days, and that's 7 issues. That was the democracy in socialist Yugoslavia. And how it ended. It wasn't censored. You know, workers said no. They said these papers are something we won't print. It insult us, it insult our colleagues who died for the communist freedom, and we won't print it. So that was the start of some interesting extrajudicial way to censor press. You don't censor it, but workers refused to print it, and you know, communists were very emotional about workers, so they couldn't force them. And this method was used mainly for everything that communists want printed. Workers have refused. So we had a new kind of democracy that was oppositional party and opposition press were not allowed. The government controlled all the printing houses, all the media production and distribution facilities. So the new government have complete control over all media produced. So they didn't need censorship. You know, they had all control before it was before production. So that was, the trials were not necessary. But people who wrote for democracy or who wrote from political magazines abroad were sent to the court, but the trials wasn't, you know, the censorship. You wrote that. The trials were much more serious, and that the crimes they were judged for were anti-revolutionary activity, treason, espionage. You know, everybody was a foreign agent, and the sentences were very, very severe. That was from 5 to 15 years in the jail. So the censorship wasn't direct, but the punishment were used indirectly for some of them. Now, when they established fully control, they had the new enemy. You know, they were not political opponents. Only in emigration, but they were held via secret service, beaten, killed, or something like that. But the truly opponents of communist regime were the intellectuals and the artists, and that was only way you could communicate some non-communist stuff between the lines. So they have to clash with them. They had a few political delicts like, you know, counter-revolutionary activity, hostile propaganda, spreading false news, and the sanctions were usually 2 or 3 years, but were going up to 20. Not 2012, but the core suppression method wasn't the jail. It was, you know, workers said no, and it was, you know, financial, social, and unemployment was the main stuff. So I will give you an example of Yugoslav Black Wave. That was a film movement in 1960s Yugoslavia. They were more artistic than official partisan film. You know, you had partisan film who isn't from Serbia, that, you know, you have partisans and URA and killing Germans all the time. So this was more socially engaged movies. They'll show some problems in Yugoslav society, but still they were on the left side of political spectrum. They were not offending communists directly. They criticized some things in the society, but all in all, majority of them were communists. Or those who were not communists were social democrats or something like that. And many successful figures in Yugoslav film were from the Black Wave. Dusan Makavev, who is the world renowned director, and you have more of them. They were recognized abroad. They were very, very acclaimed abroad, but they were forbidden in Yugoslavia. And interesting thing, their movies were shown only in police schools to police education. You know what is the enemies of the people. So let's see how oppression of these Black Wave films were. We have only two prosecuted films. We have Plastic Jesus and Early Works. For Plastic Jesus, Lazar Stojanovic got 3 years imprisonment, and the film was censored. But the situation with Želimir Žilnik's early works were different. It's he was a lawyer. He's a lawyer still, and he succeeded to defend his film on the court. But the judge later received some sanctions for letting that film go, and he got his early works to Berlinale and got their Golden Bear, which is, you know, one of the main movie award in the world. So it was very, very successful, and he thought he get with censorship, but we will see that wasn't the case. Interesting things. The films were reported by producers. You know, you invest, you know, $500,000, $1 million in some film, and then when you finish it, you go to the police and said, look what we have made for censoring. And that was insane. And around 40 movies were not distributed. So they were not censored. They were not censored in the court, but they just stopped distributing them in Yugoslavia. Abroad, they distributed them. So, you know, early works had great distribution in Germany, had great distribution in UK and US, and made a lot of money. You know, but in Serbia, you couldn't see that. So that's something strange. But let's see how they handle the directors and artists. The way was go out. You know, after the early works, Žilnik started his next movie, Sloboda, or the comic book, and it was taken away by police. He and his wife were unemployed, and even his daughter was denied the health insurance. So they make it very clear that he had to emigrate, and he went to the Germany. And majority of these directors, around 10 of them or more, were forced to emigrate. You know, Makavev got to the France, then to the US, and more of them. So that was the pattern how they censor them. Fun fact: this is the scene from shooting Sloboda, the comic book, and it was shot here in the Amphitheater 5 of Faculty of Law. So I had to put it here. So that was the pattern. You see, you had around 50 artists who were in the part of the Black Wave. One was sent to the jail. Around 10 of them were forced to emigrate, but that was enough to completely destroy that movement. You know, all others who stayed in the Yugoslavia under freedom knew what was happening, so they were smart enough to auto-censor themselves, and that was it. The conditions in the jail were a little bit more equal. The political prisoners were treated as all other criminals, same rights, same obligations. They were mixed. And the very important thing here is why. Not because to make them harder, but to mark them as equal to all other criminals. You know, political criminal is same as other criminal. When you talk against the government, it's the same as if you rape, it's same as you thief, it's same as you kill someone, and that was the core reason why they had that treatment. All other all other conditions were worse as well, and the most important thing was that they were not allowed to do anything meaningful in the prison. They were forced to, you know, plant potatoes. After they got out of the prison, they were still treated as criminals, and they have some social retribution continuing after leaving prison. So that was the communist first part of communist regime. The second is coming after 1990. It's evolution. Communists became socialist after the fall of the Berlin Wall, but majority of things remained the same. The political delicts were not more part of the criminal code, but the informal methods of suppressing the free press remained. Most economical, you know, no money, all big press was controlled by Socialist Party, and the opposition have, you know, some home printing machines and things like that. So that was the case, but opposition got stronger with the times, and it's around 1996 that opposition succeeded to create first big circulation newspapers, and that was the Daily Telegraph, started by Slavko Churovia. The Daily Telegraph was followed by the magazine The European in 1998, and it was very, very powerful mechanism of opposition to fight Slobodan Milosevic. So the regime decided to start some fight with opposition press. So they got new information law. I won't go into the details of some misdemeanors and offenses who were enlisted there, but just 4 things. The first, when someone got report the media, the first instance authority have 24 hours to start oral procedure, and after that the media had to prove that the information they publish was true. If they can't prove that was true, then they are guilty. And after the oral hearing, the court had 24 hours to give the decision, and the appeal does not postpone the execution of this decision. So that's the ridiculous deadlines. You know, 24 hours. Even habeas corpus, when you police arrest, is usually 48 to 72 hours. So that was something that was specifically designed to destroy the media, and it succeeded. The Daily Telegraph and the European were completely destroyed financially and had to move on printing above. But they were very successful, but not completely. So the old methods remained. Generally, even financially, destruction wasn't enough, so Milosevic decided to assassinate Slavko Churovia a few months later. I haven't put the picture here. So let's give some conclusions about that. First, the punishment, ironically, was used in more democratic states, more democratic parts of history of our country, as a method of suppression media. In the totalitarian and undemocratic periods, the punishment was used, but only as auxiliary method. The main method was to use extra-institutional methods, and they were much more effective. So the final conclusion of this research was the punishment was less effective than other means of suppression of media, and it was only useful to mitigate some opposition press, but not to fully suppress it. And that would be it.
Thank you very much, Simo. Okay, we can move to questions now. I would warrant that we started the session a little bit late, so maybe we can run a little bit late if that's okay. Yeah. So thank you very much to all the speakers. It was a splendid session, I think, worked really well. We have time for questions now. So just let us know. Okay, Dennehy.
Thank you all very much for your presentations. I have one comment and one question for Jan Tranžík. So you've asked if we think that the trial was political. And of course, we can discuss if it was influenced by politics, but that doesn't mean that it wasn't necessary or the right thing to do at that moment. And I'm not talking about the capital punishment. That's another question. Sometimes, well, what I wanted to say and what I think is that sometimes the society moves faster than the law does. The law should look up to the society and it should follow its development. But in the case of war, some things are unregulated. Just look at the Nuremberg trials. The crime of aggression didn't exist at that time, but that doesn't mean that the Nazis should not have been charged for it, or the trials should not have been done that way. And I wanted to ask you what you think about the political influence of the trial of Jozef Tiso. And I think that's it. Thank you.
Thank you for the comment. Thank you for the question, Isidora. Well, it is not even a question whether there was a political influence, because there was. The question is whether it was so important that it influences the result of the trial. But if you ask me about my personal opinion, yes, Jozef Tiso and the other Slovak state politicians should have been judged. And it is good that most of them were. That sentence is another question, though.
Thank you.
You must have in mind that even though situations were different, you must know. I'm researching this for 4 years, and Nina is looking at me. The trial have to be a trial, and the thing what we had in communist countries after the World War II and before and after that was show trial. So the trial needs to be focused on the law issue itself. But these trials were more like political show than they were a true trial, and there were a lot of mistakes, and that's not for the trial itself. You have that here in Serbia for some trials, because if we want rule of law and things like that, the procedure must be correct, and if we have flaws in procedure, that the judgment is also questionable. So on that kind, we have to be very careful. You know, in the France we had the same with Petain. We had the trial where the judges were not political officials, but lawyers, and we didn't have the death sentence, but it was okay, and it's not dispute about Petain in the France today, but it is dispute of Tiso in Slovakia, it's dispute of Nedić in Serbia, and some things like that.
Thank you. Just 1 second. I didn't want to say that the trials should not be based on a law. I'm not saying that an illegal procedure is a good thing. I'm just saying that sometimes there is not enough time for everything to be correct. And of course, capital punishment should not exist for that reason, because once the person is dead, there is no coming back. But in case of punishments like a few years in prison or a lifetime in prison, something that could be reversed, there is no so much fear. And you can't say that the trials after the Second World War, the trials that were influenced by communists, were not a good thing to do at that time. I'm not saying they were ideal. I'm not saying they were ideal, but after the Second World War, the millions of dead and wounded, the states that were dissolved completely, it was something that the society had to do. It wasn't legally perfect. It was not ideal, but it was necessary. From this perspective, 70 years later, we can find many mistakes, of course, but I don't consider that to be the crime of civilization, trials like this. Of course, anytime an innocent person is dead, that is a terrible thing, but considering the other punishments. So, thank you.
Can I have a comment on this? The most important thing about Tiso's trial was probably that it was indeed a trial in sense that there was some prosecution and some defense which actually worked as defense. Like in the actual political trials which happened after that in Czechoslovakia and probably also in Yugoslavia in the 1950s. Like as I said, your own defender, which was there because it was still in the law, would work for the party, and so he would demand strict punishment for you. In Tiso's case, the defense was actually trying to save their client. So that's a good point.
Thank you, all three of you. Isidora stole my question about the formal procedure of Jozef Tiso trial. So I will move on to my comment and one question for Andrey. First, the first comment about Simo's presentation. I'll be quick. There was one really interesting remark of Borislav Mikhailovich Michis, one of our most famous dissidents in Yugoslavia, where he worked for some kind of slightly opposition newspapers, weekly newspapers, and he said that when they wanted to act as an opposition, they were like praising communism too much, so that it kind of gets ironical at one point, and that was like one of subtle mechanisms to criticize communism. And the question for Andrey Kiosov, whose presentation I really liked, it was great, is could you maybe tell us something about, because you mentioned Berjaev a few times, there was, in my opinion, one of the best philosophical disputes between Berjaev and Ilić about the death penalty. Maybe you could tell us something more about that, because Ilić was, let's say, like pro-death penalty, but with his own reasons and with his own really strong arguments at the time. Of course, from this point, there's no talking about returning to death penalty. But at that point, in the beginning of the 20th century, it was really it was great philosophical debate. So if you could tell us something about that. If not, thank you anyways.
Thank you for the question. In Russian philosophy of law, in the beginning of 20th century, there were a lot of discussions on this theme, and also in Russian history, death penalty was like I'd like to say that a lot of activities tried to mimicate, like can you say, mimicate like death penalty. For example, like in 19th century, in Russian history, there was Emperor Nicholas I, the emperor who participated in the Crimean War. I think in Serbia this theme is also, you know it. And in this period of time, in the period of 30 years leading the country by Nicholas I, there were only 5 death penalties, 5 executions, officially. These 5 persons were, maybe you might know, the history of Russian Revolution at 1825. Connected also with Poland, our Polish colleagues, we talked with them about it. Dekabristy, they call them in Russia. Only 5 of them were executed by death penalty, but officially executed. But there were a lot of different types of punishments. For example, a lot of corporal punishments. And also in this type of punishments, thousands of Russians were killed. In Russia, one of these corporal punishment calls Spitsrutiny, and Nicholas I was famous for it. So in this fact, it was like an example that a lot of activities trying to be not officially death penalties, but as we see, they are. So in the 20th century, there was the same problem, and in all 20th century, there were discussions, and also philosopher Ilić took place in them, as in the end of the Soviet Union history, there was published a special book called Death Penalty. I think that we can say like to be death penalty or not to be, like that. And there were a lot of discussions about this book. Also, it contains philosophical arguments also by Ilić. But as for me, I think that his position might be quite similar as Berdyaev, because they all were religious philosophers. But at the same time, in Russian history of political and legal doctrines, we tried not to say that Leo Tolstoy, Berdyaev, and Ilić were like the group of religious philosophers, because they were different at all. Like only Christ was common, and whatever, like a lot of differences between them. So every philosopher in Russian history of legal and political doctrines has their own opinion to death penalty. And this one.
Thanks a lot, Andrey.
First about Jozef Tiso. What is the moment when Tiso party become far-right nationalistic? And what is the influence on Tiso? Do you think that Tiso become do you think that Tiso change her political opinion or her political course because they hope that people in Slovakia will have some better life about that, some benefits about that? And what is your opinion about that? And the second question is about Russian Revolution. And I may mistake. I don't sure, but I think that the penalties in Russia in 1930s is more cruel than in 1920s. Do you agree with me? And third is comment about Yugoslav politics in 1970s. I think that the Yugoslav politics in 1970s have become open, and I think the pressures on artists become weak. And I ask you that that political moment have some influence on destiny of people in Black Sea who stay in Yugoslavia.
Just very briefly, I just asked participants to be brief with their answers because we're already at the time when we should have started the next session and there are participants online waiting to present.
Yeah, so the Hlinka Slovak People's Party became more radical, let's say, after 1937, when they saw Hitler is coming to power in Germany, or he already was in power, but that Hitler is wanting to rule the Europe, and they basically thought it would be better to be on good terms with Nazi Germany. So that's where they become more radical. And yes, some people are still sentimental about Tiso's regime during the Second World War in Slovakia. So that's it probably, if this is an answer.
I would like to say that you are absolutely correct in your opinion, but I'd like to comment that all the sources were made or created in the 1920s, not 1930s. And you're absolutely correct that 1930s were much more cruel than 1920s.
Okay, you're definitely right that there was more freedom in 1970s than it was in 1940s. But it was much less freedom in 1970s than it was in 1920s. So there was some kind of freedom. But look, if you had the whole movement suppressed, if you had 40 movies prohibited from distribution, and if you had one man in jail, you had 10 men forced to emigrate, and people stopped to make movies like that. It was efficient, and it was suppression. The freedom existed, but small amount of it. It was. You couldn't make that kind of movie in 1940s. You would be shot for that. But in 1970s, these people were communists. That must be said. So they were not truly opposition, but still were suppressed.
I think on that note, I would like to thank all of the speakers today. I thought we had a wonderful session, some brilliant papers, and I'd encourage you to thank them in the usual fashion.
In order to keep up with the schedule, let's please make the coffee break really short, so 5 to 7 minutes, let's say. Grab your coffees, teas, whatever, bring them here, and then we'll move on to the next session. And if nobody minds, colleagues Anastasia and Ksenia asked us to put their paper as first instead of third in the session because they have other obligations later, so we'll just make that slight change in our schedule.